Hey everybody, Patrick McFarland here of the Liberty Weekly podcast, coming at you with another episode. This one is 147. Show notes may be found at libertyweekly.net/147. And I'm really glad I snagged Dean for a conversation here. Dean was one of the first guests on the Liberty Weekly podcast. Do you remember that, Dean?
That episode is man, I bet that's still fun to listen to. It's in both of our feeds, I think.
Is it? I think it
Yeah.
is. Yeah. I'm not recalling the episode number right now. Let me pull it up quick. But yeah, this was before Dean had started going to law school. This is episode number 25. So libertyweekly.net/25.
Wow.
August 13th, 2017, Dean.
Oh my God.
I think that was the last time that we spoke too, unless did you have me on at some point in time, or I just don't.
I wanted to when we talked about it, but I don't think anything ever came of it. Yeah, that was the last time that we spoke, which is surprising because we do have kind of the shared I don't know, shared interest, shared experience, shared sort of, I guess, life path in a way.
Yeah. Shared kind of space on the interwebs or the Liberty movement. So yeah, well, I was able to snag you after you've been through finals just this fall, and you're going to law school in the midst of the COVID era. How's that going?
What a mess. There are going to be class action suits against these fucking schools, dude.
I was wondering, one thing I really wondered was if this is going to be the pin that pricks the higher education bubble.
Okay, I have to be very careful with my words here because I am aware of some things that some schools are doing that are illegal in order to maintain enrollment numbers. Like this is the links that some schools are going to make it look like this is not hurting them is insane. I'm aware of at least one instance, and I'm not going to identify anything about this, but I'm aware of at least one instance of fraudulent enrollments where a university was enrolling former students in classes so that their enrollment numbers look like they went up in order to, I believe, defraud the state. That I've identified no one.
No, I was thinking about, I went to undergrad at the University of Minnesota, and the whole time that I was there were always buildings being built. New buildings, new multi-million dollar research centers and everything, and new student housing, and it's not sustainable. I don't think it's the same as the Misesian malinvestment, because I think that's kind of a different concept, but they're just plain making investments that they cannot sustain.
I agree. I was, when I left the University of North Texas, they had just purchased the land that the McDonald's that I would always go to, because it was just down the street from my dorm. They had just purchased that land, and they were going to build some big fucking building on it. Like the expansion was, they had just built a new student union that was finished in my last couple of semesters at the University of North Texas. It's not sustainable. Not at all. And the only reason that it's even allowed to exist, in my opinion, is because of the federally backed student loan. But this is something that people have hammered on forever and ever. So,
yeah. So how do you like, I haven't talked to you about, we were talking before, of course, about how do you like being in law school?
Well, I'll tell you, it was better before this. This has really screwed with things. This whole, the world's, the sky is falling, the world is burning, and everything's on fire. It was much more enjoyable before all this. Now I've got real problems with the way that my school is handling this, but they're not handling it really any differently from a lot of other law schools that exist. And a lot of them take their cues from the Ivies. So a lot of law schools are screwing this up. As are the organizations that sort of police the law profession and law schools and things like this. The the bar is screwing this up. The way they're handling this. But before that, when I was actually in law school and not at Zoom University School of Law, it was really, really fun. I found myself really engaging with a lot of stuff, even my less interesting classes, looking at you contracts. I was still
Yes. Screw you contracts.
Yeah. I was still like engaging with it. And one of the things that I'm most fascinated by, and this has only accelerated, is that there are things that you would think would be simple to solve in law. And those things will end up being the most complex, the most complex system you could think of to solve that problem is what was implemented. There are things that you would think would be incredibly complicated. And no, they end up being dead simple. This happened a lot in con law, I found.
You haven't had secured transactions yet, have you? Or dealt with
I believe I'm 2 semesters away from that, I think.
Okay. I don't know for anyone listening, my son, we kept him home from daycare today and he's having a meltdown upstairs, so I apologize. But so secured transactions in commercial, I'm thinking it's the class where you learn about commercial transactions. That is entirely like the United States has a version of the Lex Mercatoria. Have you studied that at all?
Not yet.
So back in medieval Europe, basically all of the merchants in all these little kingdoms came up with their own private set of laws that would govern any kind of commercial transactions. Well, the spirit of it just stuck. And in the United States, basically, my son is really crying. Sorry. Can you hear that?
It's not coming through for me.
Oh, good. Okay. Well, then I did all that for nothing. But it was all governed by private law. The merchants would make it themselves. And in the United States, they codified that into what's called, I think it's called the Blue Book. I'm not a commercial attorney. So all of it has to do, they really lax the rules on what makes a contract and boilerplate and whose boilerplate applies when you're trying to transact with these goods.
It's one of the first things when you're sitting in a contracts class, the first thing they will say is, no, it doesn't have to be written. There are 5 cases in which a contract has to be written. 5.
Right. Yeah.
There are only 5 kinds of contracts that need to be written.
Yeah. Oh, and you're making me think too. Anything that longer than a year, right? Anything. Tell me.
Anything that takes place over the course of a year or longer. There was oh my God, I made myself remember it by doing some stupid comedy bit with my girlfriend about it.
The Statute of Frauds. Yeah.
It's the Statute of Frauds, real estate transactions.
Yep.
Anything that takes place over the year. Marriages for consideration is one of them. And then there's 2 more. I can't remember.
Yeah, I never really. There's an acronym for it that we used during the bar exam. So
yeah, I think I studied that same acronym, and I went through it trying to remember it. I just started yelling things at my girlfriend. I looked at her and I went, land! Weird marriage! It didn't work. I remembered it for the exam.
Yeah. So are people still like having study groups that they're getting together, or
some people are doing stuff over Zoom? I am not. Okay, this is the weird thing, man. There are Facebook groups and like message chains, like a not unlike sort of a Slack type channel, right? I can't remember what platform they actually use, but like each section in my class, there's 3 sections in my class. Each one has their own like Slack channel that they communicate in and stuff like that. I'm not a part of any of that. And I'm not entirely sure how anybody became a part of any of that. I think it had to do with a Facebook group that someone put a link in at the beginning of the I'm not on Facebook, so I don't know. What's the difference between somebody who's not on Facebook and a vegan? Nothing at all. So I'm not a part of any of that. I actually have no idea.
Just to make it accessible for folks who, and I hope this isn't too niche humor, because I know how it is with significant others who aren't in law school. And when you get together with people who are in law school, you just kind of talk about the law, and SOs just sit there just kind of like, oh,
my
God.
girlfriend and I just came back from being at my parents' house for Christmas, and we were sitting there going back and forth about like, well, no, because what you would use intermediate scrutiny for that, wouldn't you? I mean, I think that would fall under intermediate scrutiny. It wouldn't fall under rational basis. It's too important for that, and it's dealing with a minority. I don't know why you would even. And my parents are just sitting there like, oh God.
Well, so it's kind of like a cohort. You break into sections where you're with a group of people where you all have the same classes together.
Sure. And for us, it's about 70 people per section for my graduating class.
I see. And how many sections are there? Like 4 or 5?
For us, there are 3.
Okay.
But I don't go to a large school either. There's those numbers would be far different at a larger school.
That sounds about the same from my experience. Well, okay, so since it seems like your primary interest in law school has been constitutional law, mine was torts.
Fascinating. Oh, dude, I fucking love torts, man.
Okay, well, torts is great too.
I was sitting there in torts class thinking like, okay, so we've solved the problem of needing the state for the law.
No.
Like, yeah. It exists already. We already have it. It's called torts.
So, okay, well, let's hit up the theory behind torts just a little bit. But first, let's go through. I have a question for you about con law. So my biggest beef with con law and why I didn't find it very interesting was that it is all, to me, arbitrary. It's all common law based off of a piece of positive law.
It is entirely make-em-ups. And that's part of the reason that I like it. One of the things that pointed that made, because it's because it feels like, I'll tell you the truth, part of the reason I like it and part of the reason it's fun for me is because it's a game. Con law is a game. Okay, so do you remember, you may not remember this, Lochner?
Yeah.
So there was a period of time, do what?
Refresh me on it.
Yeah, there was a period of time for the audience, and if you need a little bit of refreshing on it, because this is very fresh in my mind. I just came off a semester of con law. There was a period of time in constitutional law called the Lochner Era. It was based on this case called Lochner, in which the court basically invented an idea that liberty exists. Because it's found nowhere in the Constitution. The court basically said that you can't infringe on people's liberty. Kind of.
Is this the minimum wage case?
Yes.
Okay. No wonder it's ringing bells, because always in con law, everyone was like, oh, the Lochner court.
Yeah, the Lochner court. My professor said that anytime jurists want to insult each other, they will accuse the other of Lochnerizing. Now, my girlfriend's constitutional law professor loved Lochner. And I'm sitting there looking at Lochner going, actually, I really super like this too. But the court basically just invented this idea of liberty. There was no constitutional support for it. It was just a thing that the court was like, I mean, really, this is what this is all about, right? Is liberty. So let's just codify that. It was overturned.
By the Progressive Era court, right? So Lochner, if I'm recalling correctly, Lochner was basically said that the minimum wage is unconstitutional, right? And because there's a liberty interest.
Right. The Lochner, actually, I think it might have been the bakers. The number of hours that a baker is allowed to work.
Right. Oh, yep. Okay. This is ringing bells.
Coming back, right? Lochner versus New York, blah, 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 blah. Yeah, this was the Baker case, where the number of hours that a baker was allowed to work was limited by the state, and the they basically sued and said, we want to work all the hour. Why would you do this? And the state had said that, being a baker for long hours was dangerous, which it may have been. And the court was like, yeah, but you get to decide that for yourself because of liberty. Liberty was made up. That's the thing that like people, this case and the way that it's treated is the most eye-opening part of constitutional law. Because there are people, specifically conservatives, who think that constitutional law is a method by which liberty is protected. And that is not true. Constitutional law is a method by which the state's police power is expanded until it goes too far. And what too far is not defined.
It's made up.
Yeah.
Right. I'm okay. So correct me if I'm wrong. I'm pretty sure I can say this, though, is that nowhere in the Constitution is rational basis review, intermediate scrutiny, or strict scrutiny detailed.
They do not exist in the Constitution. They are totally made up.
in fact, the 14th, and this is a very crucial piece to understand, and one thing that I never understood until I was in law school, but the Constitution does not apply to the states, or at least it didn't initially. The only reason we have constitutional review in the Supreme Court and the federal courts is because the 14th Amendment was passed, and the Supreme Court interpreted it.
Constitutional review of state law.
Right. Yep.
Right.
Because the 14th Amendment was passed, and then the Supreme Court interpreted the 14th Amendment to mean that the Bill of Rights applied to the states. They took one thing at a time and ruled that it applied to the states through the window of the 14th Amendment. And
one of the most interesting things about that, in my opinion, there's three very interesting things. The first is that the most recent one was in 2005, and it was the Second Amendment. The second is that the Third Amendment has never been found to exist against the states. There's never been a case upon which they could find that. So the Third Amendment is not incorporated. And also the necessity of a grand jury, I believe that's part of the Eighth Amendment, has not been incorporated against the states either.
Interesting.
And the fact that we only got to where we are now, we still have two chunks of the Bill of Rights that are not yet incorporated. The most recent thing to be incorporated was the Second Amendment, and it happened in 2005.
That's insane. Was that the Heller decision?
Yeah, Heller v. DC.
Yeah. Yeah, I mean, it's just insane. And this is something I was talking about with Stefan Kinsella, too, is this idea that it's just basically because you have positive law, because you have a piece like the Constitution, which is a piece of positive law, it was just kind of made up and imposed. It wasn't natural as opposed to the common law string of decisions. Sure. You have a bastardization of the common law where judges aren't interpreting precedent. They're interpreting precedent of a statute.
Right. Exactly. And a statute whose position as a statute is itself questionable. We know this because Spooner wrote very long-winded theses about why the Constitution is not really a law anyway. Which is one of those things that it's kind of hair-splitty, but you have to be hair-splitty in law. In fact, I credit you with turning me on to a lot of Spooner's stuff. I wouldn't consider myself a Spoonerite if you hadn't done that episode on No Treason. I maybe would have found it later, but like this is the way that things went. Is Liberty Weekly talked about No Treason, and I was like, hold on, I need to read this. Awesome. And I'm actually like I describe myself as a Spoonerite. In a lot of cases. But in any case, yeah, that's something that people don't really understand about constitutional, especially conservatives, don't really understand about constitutional law. You mentioned rational basis, intermediate scrutiny, and strict scrutiny. Okay. Intermediate scrutiny, if you're kind of in my position and you just came off a semester of it, your professor might have called it rational basis with bite.
I was going to say that just now. Anyways.
Mine did.
Yeah.
Mine did call it that. So rational basis, this is how made up this is, okay? The rational basis test basically is laid out such that a state whose law is being challenged doesn't even have to tell the court why the law exists. The court, if any member of the court basically can think of a reason why the law might exist, anything that it might accomplish that could be, it doesn't even have to be a good thing. It can be stupid. In fact, that's part of one of the opinions that established this test was the idea that, I can't remember who wrote this line, but it was, to paraphrase, something like, it is not our place to determine whether a law is imbecilic. And if the court can come up with a reason that the law might exist, it gets to stand. It doesn't matter if it infringes on a constitutional liberty or a constitutional right, whatever it may be. It gets to exist because the court was able to think of a reason that it could exist. The state doesn't even have to make the argument. The court can make it for them. That's rational basis. That's how made up this is.
And that's the thing that I hate about I lost it. Sorry. This happened last night. I was recording with Jose Gallison and I just had a brain fart. No, that's what infuriates me is this thing about how we give so much deference to the legislature, and I get it. It's a separation of powers thing, and
the courts.
But
to expand on what you said as a separation of power things, the court basically says we don't want to infringe on the results of democracy, until they do. I'm sorry.
Right.
Continue.
Yeah, and it bugs the crap out of me. And one thing, I did one of my long paper requirement on this was how. Oh boy. Before the Constitution was ratified, there was a string of decisions in the state Supreme Courts saying that it was an impeachable offense for the Supreme Court in the state to declare a law unconstitutional unless it was a clear case, unless reasonable minds couldn't differ about whether or not.
Wait, is this the are you referring to a federal question thing or like?
Well, this.
No, I know what you're talking about. The idea that a state court cannot make decisions on the federal Constitution unless it's obvious.
No, this is calling into question the entire idea of judicial review, because before Marbury versus Madison, it wasn't clear that the Supreme Court had the power to declare laws unconstitutional.
Actually, yeah, I don't know how many people know that. Judicial review's made up.
Yeah, right.
And Marbury versus Madison was basically like, no, the court has the power to review laws and declare them unconstitutional. And everyone's like, wait, what? Where's that in the Constitution? It's not. But they gave it to themselves.
Right. Yeah. I mean, it would seem like, in a way, it seems like it logically would follow that they'd be able to do that. But no, that's not what the Supreme Courts in the states did. I mean, that in of itself is a violation of separation of powers, I think.
Right. Oh, it's a violation of federalism, certainly.
Right. Yeah. And so it's so interesting. I'll link it. I've talked about it a lot on the show. I think in episode 2. But William J. Watkins Jr. he wrote a really long law review article about this. So I can't claim this thesis as being my own, but all of it's there, and I'll link it in the show notes page. It's worth the read. It blows your mind.
It's fascinating stuff. That's part of the reason that I found constitutional law so interesting and fun, and also because, look, okay, so I'm not. Let me think of a way to actually begin this sentence that's going to make it make sense all the way through. Have you ever watched like videos of penetration testers and stuff like that at like DEF CON talking about how you can penetrate networks and even like social engineer your way into secured buildings and shit?
I haven't seen that. I was wondering where you were going with penetration testing.
Yeah. Well, I am not. I will not pretend to know anything about that or to be any good at it, but I'm fascinated by it. And that's one of the things that exists in con laws. If you're thinking like a hacker, basically, while you're going through con law, the holes are massive, gaping holes in the structure of this thing. And the right person with the right court can change the face of it in a single case. One good example of this, and this is what I was, when I did that episode on the Fourth Amendment and cats and the idea of surveillance, one of those holes is about to collapse. I believe personally, because Sotomayor, by the way, conservatives love to shit on Sotomayor. She's your best friend when it comes to your privacy. Sotomayor in the Jones concurrence talks about how the standard for the third party doctrine, basically, the idea that if you have at all given information to a third party, your Fourth Amendment right in that information is void, which doesn't really jive with surveillance capitalism. All of your information goes to Google. Google's a third party. All of your information is all of your First Amendment interest in your information is void.
Your Fourth Amendment? I want to understand. Your Fourth Amendment interest in that information is void, or your First Amendment?
Fourth.
Gotcha. Okay.
Privacy interest. Your privacy interest in that information is void. Because it went to a third party. The third party doctrine made sense before surveillance capitalism. Now it doesn't. Mm-hmm. And that's something that Sotomayor said in the Jones concurrence, which might be my favorite piece of legal writing ever. And she said, we need to change this. This needs to go away. And the court seems to be amenable to that idea, to getting rid of the third party doctrine. There are a couple of people on the court who are not looking at you, Alito, you dick. But that's one of those glaring holes. And that's one of the things that could be attacked. If you think about constitutional law like a hacker, it becomes much more fun. Because there's all kinds of issues like that all through the thing. And it's because it's all make-em-ups. There's no constitutional basis for any of the tests that we use to determine whether a law is constitutional. There just isn't. It's just like in Roe and Casey. They got their own test, basically. The undue burden standard. It doesn't really exist anywhere else. They didn't get intermediate scrutiny. They didn't get rational basis. They didn't get strict scrutiny. They got their own weird undue burden standard with Casey.
Do you want to explain to the audience? I know you're raring to talk about Casey and Roe.
Love it. I just love it because I love making fun of conservatives and liberals alike who think Roe v. Wade matters. Like, it's not that it doesn't matter at all. In fact, Casey talks about upholding the primary finding of Roe. But it doesn't give us any standards that we use in law. Kcv Planned Parenthood is a case that came later that established the undue burden standard, basically saying that if a law places an undue burden on a person seeking an abortion, then that law becomes unconstitutional. It's a balancing test. And Roe v. Wade put in place a totally different test. It was a viability standard that the court is going to make its way back to. But that's one of the things that I find, again, it's all make-em-ups.
I remember, so this was a very formative event that happened when I was in high school. And I was, always someone who was really interested in liberty and the founding fathers, but I was a conservative. I didn't know what libertarianism was. And I remember writing an essay for a scholarship. And my mom is a legal professional, and I wanted to talk to her about this because this was my first time really kind of playing around with these ideas. I screwed off in we had government class, in like sophomore or junior year. I didn't pay attention at all, but I was writing this article, and I remember it was about DUI checkpoints. And I was thinking about it, and she was explaining to me how the court balances liberty interest versus the interest of the state. And I was like, okay, well, it says protect against unreasonable search and seizure. They have no probable cause for this. How is this legal? And it wasn't always legal. They were declared unconstitutional in certain areas, but
right.
It blew my mind that we would even consider that the state would have an interest in doing anything.
Carving massive gaping holes in what should be pretty clear-cut constitutional liberties, constitutional rights, rather. Carving massive holes in them just because the court can think of a reason that a law could exist. That's all rational basis does.
Oh, there's exigent circumstances because when you knock on the door, they might be flushing drugs down the toilet.
God damn, dude. I have been so mad about no-knock warrants for the last 2 days. The number of people, they decided to fire a couple of the cops that were involved in the Breonna Taylor shooting. And so every time I see Breonna Taylor news, I can't help but comment on it. And it always gets a bunch of people saying that as long as you have a permission slip, home invasion is okay, coming into my mentions. And it makes me so angry. Like, say what you want about her boyfriend. Who cares? You wouldn't be able to tell the difference between a home invasion and a home invasion with a permission slip. Stop defending this. It's been driving me nuts. But yes, you're exactly right. Exigent circumstances, they could be breaking the law in there.
It's just crazy. Yeah. I mean, carte blanche, you find a reason, any reason, you get it.
Yeah, I get to break into a house because I got a permission slip and they might be breaking the law. Okay, fucking whatever. Go for it, I guess. I don't...
Although I did have a case, it was kind of a one-off case where my client was smoking marijuana at the local university. And there is a certain decent case law, at least in this state, where if an officer can't just say, I smell marijuana, unless they can prove that with their experience that what they're smelling is marijuana, and they know enough to know that it is marijuana, and they can undoubtedly tie it to one specific individual. So like the only point where it would work, it seems to me, is where the officer pulls up to a car and it's Cheech and Chong in the car and the windows open and the smoke rolls out
of the window. Yeah.
I mean, I was thinking about briefing this and doing a motion to suppress. Because it was just like, I don't think I would have won, but they were sitting behind one of the dorm buildings, and there was an officer who had drove by the dorm in December with the windows open, according to the officer, and they smelled marijuana smoke.
And you're kind of up north a little bit too, so that's not, you can do that. You can get away with driving with the windows down in Houston in December. You can't really do that where you are, I don't think.
Yeah, well, and I'm like, I mean, so she did stop and investigate, and she walked around the building and saw these people sitting on the park bench, and were like, "You guys smoking weed out here?" And my client said, yes." And I was like,
"You guys doing the pot?
Are you doing the pot?" And but I guess my argument was like, okay, well, the parking lot was full. You can see on security on the officer, not the dash cam, but the body cam footage, that there's other students walking around. How do you know that the weed smell didn't come from an open window or any of the number of parked cars or someone walking around? But the real bugaboo is that she had to walk around the building.
Sure. The other issue too being that I don't know if that answer to that question should be admissible anyway.
I thought about that too, and it was I'm just not recalling what my arguments were, because you can. What's your argument? Well, I try and think of mine.
Well, because there was no first of all, they weren't in custody, they weren't being Mirandized.
Right.
They didn't have any they did not have any protections at the time that question would have been answered.
And it's an incriminating statement.
Right.
Yeah.
I don't see how that would jibe with what was the case that I can't remember the case that established there's some standard there. It's not the Miranda case, it was a later one that's I don't know. Anyway, yeah, I would
right, yes. Well, I thought, no, I'm remembering now, because it was whether or not they would be seized for the purposes of Miranda. And in that situation, my argument is that they would be seized in that situation, because they would be seized because a regular person wouldn't feel that it was okay to terminate that interaction. And one of my arguments is that they were in a dark behind the dorm. They were alone. They were, in a way, their exit was cut off by the police officer, and a normal person wouldn't feel free to leave. She seized them by asking them an incriminating question that implied that if I walked away right now, she would chase after me.
Right.
So
That
I
is
thought I could have won
the
that.
standard. Actually, I had forgotten that. That is the standard. You are in custody if you feel like you're in custody.
If
a
no,
person
you're in custody if objectively a reasonable person would feel like they were in custody.
not a subjective standard. It's an objective one.
Yeah.
You had said something earlier. Oh my God. It made me think when you were saying you couldn't remember exactly what your argument was and stuff. This is something that I find very interesting. I had this misconception about lawyers before I went to basically before I finished my first semester of law school. You learn very quickly that it's not the case. People think that lawyers have like a Rolodex of knowledge of the law in their head.
Right.
And in some ways you might. If there are things that are particularly interesting to you, you might remember them. If there are things that are within your specialization after a few years of doing that, you might remember them. But lawyers have to research every case. Like there are some cases that are very simple where there's a very elementary thing that can answer the question, but in most cases you've got to look at case law for everything.
Oh yeah.
Lawyers do not have a Rolodex of legal knowledge. That Rolodex is just a Rolodex of starting places for the research that's actually going to tell you the law.
Let me tell you a few very, very niche issues that I could give you like in a 1 hour or, a 15-minute oral argument on right now.
Right.
One, the Daubert standard as it applies to brain spotting, which is a clinical technique in therapy. It's kind of pseudoscience, but it says that your memory is attached to certain directions that your eyeballs are pointing.
Oh my God.
Do you think that let me guess. So do you, and for those of you who don't know, the Daubert standard it's Daubert versus Merrill Dow Pharmaceuticals. Have you had evidence yet, Dean?
Yes.
Okay, so the Daubert standard, it's a federal standard that most of the states have adopted for whether or not an expert witness is qualified. And would you think that someone who practices this technique would qualify under Daubert? There's a few prongs, like whether it's the topic has been published and is widely accepted in the scientific community. Fill me in on more, because I guess I said I could give a 15-minute oral argument, but maybe not.
Well, that's exactly kind of what I'm getting at. Is like you can't just pull this stuff. You got to do research before. But yeah, I'm trying to remember what exactly the prongs are. But
well, do you think, just off of hearing this, it's a trauma-based therapy where the whole thesis is that you can access different memories in your brain based on where the client is looking.
Okay. There are two ways I could answer that. I could try to answer that based upon what makes sense, or based upon the fact that bite mark evidence is allowed in court.
Yeah.
So I'm gonna say it's gonna be allowed, but it's stupid.
I won the motion, Dean. I won the motion, and it came in. So I was happy with that.
That's excellent. That's the kind of thing that people have misconceptions about not just the legal profession, which I'm not yet a part of, but the law generally, which I can't speak on with very much expertise, but I can speak on as a law student. It doesn't make any sense. It's not concrete. It's not from on high. It's not special. And when there are a lot of lay people, again, especially conservatives, who will act as if the law is a moral arbiter, or as if the law is somehow a moral imperative, that following the law is a moral imperative. It's a legal imperative to follow the law, of course. There is no moral imperative to follow the law. There's no ethical imperative to follow the law unless you've made it an ethical imperative, as in you're a lawyer or something like that. This idea that the law maintains some special place above everything else as a standard of living. Like there's the 10 Commandments and there's the law. is nonsense. It's entirely made up. It's entirely just it's and it's affected a lot too by just like every now and then there's a shitty attorney who is making the right argument and the other attorney's better, and the I shouldn't say shitty attorney, an attorney gets outclassed. There's an attorney that gets outclassed. They were making the right argument, but they lose anyway. And then the law changes because for no reason other than one guy didn't make a good enough oral argument.
Mm-hmm.
That happens. There's no moral, there's no standard of the law as a moral arbiter of anything. It's entirely made up. It's people trying to make organization out of chaos. When in a lot of cases I don't really think it's even necessary, but whatever. It's just a fascinating thing. I find myself fascinated by it every day that I'm sitting there learning about it. There are some days that are incredibly boring, but there's always some little nugget in there that's like, that is bug nutty. Why would they do that? And it's just because it's been that way for 200 years.
And one thing I always had trouble with in law school is because they always give you like these hypotheticals, or they will give you a practice case with facts that they made up and authored specifically for practice. And it's, do you find isn't it so hard to remember the facts of a case when you're doing something like that?
Yes. One thing that I actually found to make it easier, my torts professor, incredible legal mind, incredible legal scholar. She's amazing. Everybody loves her, and her exams are hard. But she will take real cases, and she will make her exams are real cases. She might put two cases together, and you have to issue spot two different things, or a few different things based upon what issues are in this set of facts and the set of facts that follow. Like she might do one that is a false imprisonment after an assault, right? So you have to like issue spot both of those things, and the assault is from one case and the false imprisonment is from another, and they just kind of flow together. Those I found easier, but it can be difficult. It can be really difficult to issue spot made up cases because there are some things that just don't make sense. But yeah,
this is one thing that won't even it didn't occur. It probably won't occur to you because it didn't occur to me, but you will probably never have a battery case. You will probably never have a false imprisonment case, sheerly for the reason that insurance companies don't cover that liability. And you are very rarely going to have a litigant who has the assets that would make it worthwhile to go after them for it.
Yeah, that's exactly that. And also, I mean, false imprisonment has to be done under color of law, right? Otherwise, it's just kidnapping. So there's a QI issue there, isn't there?
I don't think so. I mean, the times that I think about it is we had this one case I remember studying in law school where there were repo men that repoed a car, except the owner was in the back seat of the car, and he sued them for false imprisonment. I don't know. I don't think it has to be under color of law.
Oh, okay. I might be confusing it then.
Or if you have a store who falsely believes that someone has been shoplifting and they detain them for longer than is necessary.
I had an LRW assignment over shopkeeper's privilege. That's you want to talk about a mess in law. That is an absolute mess.
Yeah.
It's just so
well. Good luck showing damages for that. I mean, you could maybe collect from a business, but what is an hour of your time worth? $20?
Right. And you're gonna have to. It depends on the state too. Like in Texas, I don't think an hour of your time is actually worth anything. I think that case gets thrown out. If it's an hour, that case gets thrown out in Texas, I think.
Yeah.
It's got to be like ridiculous. I don't know. I find it. I mean, you would have to show emotional distress, basically.
Yeah.
The only way that you could do that.
Yeah, or you'd have in the damages from oh, well, I was humiliated in front of a bunch of people. And then so because of that, I went to a therapist every week for a year
Right.
at $1,000 an hour.
Okay. Do you want another example of how everything is fucking make-em-ups?
Yeah.
Okay, I think this is my favorite thing I learned in constitutional law. I think this is my favorite thing. Taxpayer standing.
Right. Yes.
So, taxpayer standing is the idea that as a taxpayer, if you are dissatisfied or you think that your money is being spent in an unconstitutional way, that you should be able to bring suit, right? Because it's your money. The Supreme Court says no. No, once the money becomes the government's money, it's not your money. You do not get to bring suit because you don't like the way they're spending your money, even if you think it's unconstitutional. Except there is one exception to this rule, and it is the Establishment Clause. If you believe that the government is spending money in a way that violates the Establishment Clause, you may have taxpayer standing, because otherwise it would be impossible to find a plaintiff. You can't think of an example of an Establishment Clause issue where there's going to be a plaintiff with regard to, so taxpayer standing is the only way that you can challenge that. That's the only place it exists. Once your money goes to the government, they can do whatever the hell they want with it, including killing brown kids who were born in Colorado on the other side of the world. And you don't get to say anything about it.
And another example of this is discretionary immunity, and this kind of plays into the DC case where we say there's no duty to protect. What is the name of that case again? I did an episode on it. I should know.
Is it Walker v? No, it's not.
Well, this is the one that Mance Raider talked about all the time. I remember when Mance first started doing his show, and I asked him to come on mine. He was one of my first interviews too. I was so nervous.
Really?
I was, dude.
I actually stood Mance up. I had a pretty big life event happen that made me real depressed for several weeks, and I slept through an appointment to record with Mance, and no. he hasn't asked me on since.
I'll throw in a good word for you. Warren versus District of Columbia.
Warren, DC. I just pulled it up. Yeah.
Yeah. Okay. So there's this whole idea is that the state has certain qualified immunity. They can't be held enforceable, or they can't be held liable for things like not enforcing. This is another one, Castle Rock v. Gonzalez. They can't be held liable for not enforcing a restraining order. Also, they can't be enforced for where they failed to protect you, where they didn't have a positive duty to protect you. And it goes into these other things like, I'd have to check into this, but I'm pretty sure you can't sue the government for designing a road in a piss poor way that causes an accident, or failing to fix a pothole that destroys your vehicle and you get terribly injured.
This all comes out of the same thing. There's a concept in tort that you can't, and it comes out of the same idea of immunity where, and I think this is actually part of Warren. You can't sue for anything that happened to you. Basically, you can't sue for anything that happened to you as a result of an officer's actions unless you were in custody.
Oh, yeah.
Like, if the officer will have a duty to protect you if you're in custody. If you're not in custody, they don't owe you shit.
And part of the court's reasoning for that is, okay, well, if we allowed this, we'd get sued all the time. And it's like, that's not an argument.
What does that mean?
It's like, okay, well, take this for instance, like if a shop was negligent in the maintenance of a stairwell or something that led to the entrance to the shop, and the stairwell collapsed and your client died, that's liability right there.
There's a grape on the floor at Walmart, and it's either been there long enough or one employee knew about it. They are liable for the person that slips and falls on that grape. They just are.
Right.
And
rightfully so, I think.
Sure. Yeah. And that same standard is not applied to the state.
Right. Yeah, and the reason why I say rightfully so, and this is the perfect segue into, I was going to pick your brain about torts. I think that, so there's this conception, and it started with the McDonald's hot coffee case. It
It
goes
did.
earlier than that, but I had
That
Monica
one
Perez
that
and
blew
Brad
it up.
go that what?
I said that was the one that blew it up. That case.
Yeah, the tort reform issue. Well, I had Monica Perez and Brad Binkley on in from the propaganda report. Monica Perez has a JD. I'm
I
pretty
didn't.
so we were talking about this. She worked on Wall Street, man. I'm pretty sure. Um, but we were talking about this case, and so what people don't tell you is that the plaintiff in the McDonald's hot coffee case, she died in part because of her injuries. She
And
had
they were bad. This was not just to clarify for the audience who may not know about this. In the hot coffee case, the case where the woman had that coffee, there was coffee that she had in her lap. They were actually parked. McDonald's claimed that they were driving. They were actually parked in the parking lot, and the coffee spills in her lap. The wounds that this woman received from this coffee are horrifying. This is not a case where, oh, it burned a little. No, no, no. This coffee was unsafe to serve. And there's a massive misconception, in part due to McDonald's basically taking over the media narrative of this issue, of this case. That it's a bullshit case or whatever. It is not. This woman was seriously harmed by this coffee, and it was served well above even McDonald's own standards for how it should be served.
Well, and I think part of the issue is that their standards were ridiculous, and it's that it was their standard to heat the coffee up to an unreasonable temperature. And I don't know if it was a cost-saving measure, but there was some economic component to that.
Right.
But I mean, I would say it's the equivalent of serving someone like boiling magma.
Yeah.
Or some, you know.
The wounds that this woman received were not. Look, I'm somebody who's stupid, and I get burned a lot. Okay? In the kitchen, in life. When I was a child, I burned myself with a car cigarette lighter because I was curious. Okay? I'm an idiot. I know from burns. This was ridiculous. This woman's injuries. They were bad.
And a part of it too is that if you're McDonald's, you know that a certain percentage of folks are going to spill their coffee. That it just happens.
Sure.
People don't spill coffee always because they're negligent. Sometimes they do, but it's going to happen. You know, as you're handing a coffee through the window, some percentage of them will be dropped or spilled or what have you. She was trapped in her seat because of the seatbelt. She couldn't get up when she. Right. So, where was I going with this? But basically, there's this
tort reform, and I'm sorry I got off on the hot coffee thing because it pisses me off.
No. Well, that plays perfectly into the point I'm trying to make, is that conservatives have this conception that people who sue because of personal injuries are money grubbing. They want to blame other people when it really was their own fault. There's this idea of like express assumption of the risk, where you just accept risk when you do things.
My point, that caveat emptor, like people will say caveat emptor, that doesn't have anything to do with that. And also, secondly, that doesn't exist. There are implied guarantees anytime you sell a thing that you have to abide by. Like caveat emptor is basically gutted. There's no real caveat emptor anymore.
And in express assumption of the risk is similarly gutted as well.
Right.
Libertarians should be all for plaintiffs' attorneys, because I think in a stateless society, this, instead of regulation, you would have common law, you would have product liability attorneys and personal injury attorneys who would regulate industries purely through lawsuits like this.
That's exactly right. I agree with that entirely. There was an interesting case. Do you know Legal Eagle on YouTube?
Yeah, I've heard of it. I don't know if I've heard
it. He's very smart. He makes it very digestible. As a result, it feels a little bit normy, right? For someone like you and me who have exposure to the more complex sort of applications of law. But he makes it very digestible for a lay audience, and at the same time, you know, bringing up some of these more complex issues in law. He had an interview with the plaintiff's attorney who was handling the Monsanto case.
Yeah.
The glyphosate case. He interviewed that guy. And the dude was describing what he did in the courtroom. Like, okay, there was a moment, he claims it was accidental. And I believe him because this has happened to me before, cleaning out like those pump sprayers and stuff. I'll believe it was accidental. He was describing how you use this sprayer for Roundup. And he was describing, he pumped it up, and also they had washed it out with water beforehand. So he's putting pressure in this container, and then he lifts up the wand and he goes, and he just kind of go like, and water comes out of it. Right at the jury.
Oh no.
The jury goes, and the judge is like, the judge got on his ass. I'm sorry. It was just, they had to go in to chambers to decide whether or not to tell the jury that it was just water.
Oh, yeah, of course.
It's so funny, but that's what you're just, like, plaintiffs' attorneys, like in tort, are the guys that bring these, especially large corporations, to task on this kind of stuff. The issue, I'm of two minds on some of this stuff. I love tort. I love tort as a concept, and I honestly find tort fascinating. But my dad's also a business owner, right? He's the president of a family business. Became the president after my grandfather died. This is a business that's highly industrial, and also some people are idiots. So I find it where, like, and if an employee of his did something stupid that's clearly against their policies, and he posts like a random policy, every week or something on the door, like the policies exist and are talked about. But if one of his employees decides to be an idiot and does something stupid, my dad's company is still liable for that. I don't know how I feel about that.
That brings up a good point. In Andrew Kern, I don't know if you're familiar with the Principled Libertarian.
Heard of, yeah.
I shout him out sometimes, and I know he listens to this show. He made a very interesting point. He always provokes my thoughts in an awesome way, but he made a post about how he thinks that respondeat superior violates the non-aggression principle. And I need to read about this and think about it a bit more, but there is something that for those who aren't familiar, respondeat superior basically means that an employer is liable for the acts of an employee if those acts fall within the scope of employment. It's kind of like an agency type thing. If someone is your agent, it makes the principal liable for the acts of the employee and the agent. And I don't know how I feel about it. Like, I think if respondeat superior didn't exist, most of the cases that I have outside of car accident cases wouldn't exist, because I'm not going to sue the project manager. I'm not going to sue the department store manager for an obstruction that unreasonably put my client at risk for tripping, breaking.
That is where personal liability would stop in that kind of instance. Is you wouldn't be able to take it up the chain.
Right. Well, then, do we have employees carry liability insurance just as an umbrella thing, or is that part of your homeowner's insurance that we package it in?
Maybe it's part of the employer's insurance. Maybe the employer has to carry. Maybe it becomes the norm to make it part of an employment contract that an employer carries liability insurance, and the employer could protect themselves in that way too by basically saying, like, as long as you're following the rules. But then, of course, you'd have to deal with insurance companies not wanting to pay out. It's complicated.
Yeah. Something would be figured out.
I would think so too. But I do have an issue with, again, for a business that maintains its policies and makes its employees aware of its policies and does the safety trainings and does the things that you need to do to keep a place of business safe for the people who work there and for the public, they do everything they can. And then an employee decides that they want to be a moron that day. And then that business could be put out of business entirely, especially if it's a cash poor business, like a lot of industrial businesses are. I don't feel good about that part of it.
Well, let me throw something else at you. I mean, it is true. So what you're saying, yes, each business as a part of just their daily operations, they have insurance that will cover these situations, even for respondeat superior. And the insurance company handles the litigation. It's a part of the insurance contract that the insurance company will hire a lawyer to defend you.
Which, of course, they would want to because they don't want to pay out a claim.
Right. Yep. And sometimes, there's the nuisance costs of, okay, well, we think we're going to win, but we'll throw you a bone just not to sue us.
Or just, a settlement that's maybe not what you would have won in court, but it's a lot to the person who's suing.
I'll tell you, I have cases like this right now, though, where I'm looking at suing a business, and I will sue based off of, respondeat superior, your employee clearly fucked up here. But I will also include separate claims of negligent supervision and training and having a bad safety culture. And you know what I get from that, Dean?
What?
I get discovery up the wazoo.
Yes.
At that point in time, I get all the employment manuals. I get, the safety meeting checklists. I get I get all that stuff. And oftentimes
all that stuff you have to go through. But yeah,
it is, and that's what it's like. Okay, well, you need to be someone who's willing to put in the hours and look through.
You got to be willing to sit there and just flip through documents.
I'll tell you what, I have a case right now where it happened in a construction zone, and primarily my case is against the other driver because it was a car crash, but the other driver countersued and pled in the construction company, the contractor too.
Oh God.
And I was the asshole who requested everything in discovery from this construction company, all of their safety manuals, all the DOT manuals, everything. I mean, I'm talking thousands of pages of discovery. I was that guy. So,
yeah. But that's the kind of thing, that is the kind of thing that makes me a little uncomfortable, is when you have a business that does do all of that right, and they're still going to be held liable for their employee just being an idiot.
Yeah.
I just don't know. I personally don't think, I don't know. It seems like it seems like a way that the law punishes, especially small business.
Yeah.
But I don't know how you handle it. I just don't know how you handle it. It's complex.
I am sympathetic to that. And I feel like, but I guess my backing for it from a libertarian position is that you are aggressing against someone if you put their property at an unreasonable risk of damage.
Yeah, I agree with that. I think that's true. There's also, though, like the personal responsibility angle of it too. And I'm not pretending to have any answers. I truly don't know how you handle this, especially because respondeat superior has been legal principle for so very long. But I don't know how you would handle it. But I can think of, there are philosophical arguments to be had on both sides. The idea of personal responsibility, like, shouldn't the person who made the mistake be liable as opposed to someone who gave them the means to not make that mistake? If they did do that. Now, if a business has a shitty safety culture and they don't uphold their policies and they don't make sure that that those things are drilled and sort of handled, I'm all for them being liable. They made their bed, as far as I'm concerned. It's in those other situations, though, that I get shaky on it. I don't know how you handle it.
One thing that just occurred to me is this kind of causation argument is like, okay, well, sure, respondeat superior maybe doesn't quite make sense, but from a causation standpoint, that employee wouldn't even be there to screw up if it wasn't for you hiring him, making him your agent.
Right.
Yeah. I mean, maybe every employee should carry some kind of liability insurance. And maybe in a free market system, it would be something that would be built into your conditions of employment, and it would be a few dollars per paycheck.
Sure. Or what do you in that situation, though, what do you do with, that incentivizes those kinds of suits, though, too. If there's an insurance company there that's just going to pay out a settlement or even take it to court, whatever it may be, that incentivizes those kinds of suits. And some of those may not be as meritorious as others.
Yeah. And And as an employee, I guess you're as a PI attorney is paid off of contingency mostly. So you
Right.
don't get paid until you get a settlement. While if no one is insured, who are you going to sue? I mean, businesses have to be insured because they could lose their assets. There could be liens put against their property. They have some liquid assets that would be paid out. Well, moreover, so if they didn't have insurance, that would be the case. But if the individual employees were liable, I mean, Jane, who works at the checkout aisle at Kmart, she doesn't have any liquid assets. I don't even think that you can put a lien on someone's residence. Do you know this, Dean?
That I do not know for sure, but I would bet that depends entirely upon jurisdiction.
Yeah, I think you're right. I think in the reason I don't know, like we were talking about lawyers earlier, I've never had to do this yet because it's always insurance companies. I don't know if you can attach a lien to someone's personal residence or their personal vehicle or other personal property, like, their lawnmower or what have you.
I would bet that is entirely jurisdictional.
Yep.
I would bet in some states you can, in some states you can't. But that's one of those things that it's one of those sticky situations that exists in law, again, because law is not a moral arbiter. So there are things that exist in law that, I mean, there are arguments to be had about whether or not they should exist. Respondeat superior is one of them.
Yeah.
Immunity is one of them. Qualified or otherwise. Which is another thing, actually, this kind of ties into tort, the idea that qualified immunity, so have you talked about qualified immunity on your show?
Not super in depth. There's another concept, at least in Wisconsin statute, called discretionary immunity, where officials in government, as long as they're acting within a discretionary position, can't be sued unless it's for certain things like non-enforcement of the law. Actually, I just was researching this. So go ahead. Sorry.
What we're talking about with qualified immunity and discretionary immunity, which is a term I've heard. I'm not sure we have it in Texas. I'm not positive. This is one of the issues actually with the multi-state bar, is that in law school you don't get as much of your state's law as I think you probably should. In any case, this is all sort of a child of the tort concept of sovereign immunity, where the state is immune from civil suit, effectively. And it's codified in different ways. It's codified, like what you just described as discretionary immunity is one way that gets codified. Qualified immunity, generally, you cannot, to kind of explain it just on a very surface level, if you bring a civil suit against an agent of, it's usually law enforcement, if you bring a civil suit against this person, unless in similar circumstances, another agent in a similar position has lost a civil suit of that kind, they are immune. So there has to be precedent for the situation for which you are suing in order for qualified immunity not to apply, in order to actually get your case even heard.
Well, and the standard for that is so BS too, because it's like
there has to be precedent for this thing we refuse to make precedent for.
Right. Or we make the standard what a reason if the police officer acted in accordance with his training.
Right.
Another standard,
which we know is shitty. We know cops are trained like poorly. We are aware of this. So that's what qualified immunity basically is. It's very surface level, but that's what it is. This to me is a I actually kind of, I tried to bring this up with my constitutional law professor. He kind of shot me down, but I was actually trying to make the argument that this is an access to the courts problem, that you don't have access to redress of grievances while qualified immunity exists. And he was saying that that's kind of a weak legal standard because you technically do have, you can sue, it's just going to get thrown out. So you do have access to the courts, you just don't. So I think he's right. It is kind of a weak argument when you say it that way. But regardless, this is a thing that is pervasive, and it's another one of those things that, just like where the officer doesn't have to protect you unless you're in custody. If they fail to do that, then there's qualified immunity.
Right.
So there's two backstops to an officer having to take responsibility for their actions.
I'm looking at I'm totally going to plagiarize one of my practice guides here, but it talks about the doctrine of qualified immunity, and I'll just read it while we're on the topic. I don't think I've covered it, but it says,
Sure.
unlike absolute immunity, which generally applies to both federal and state law claims, qualified immunity is a federal law concept limited to suits brought against state officials under 1983, which is a federal statute.
The
Qualified
statute 1983, just to it's the statute for infringing upon your rights.
Yep. Qualified immunity applies only to claims for damages, not to claims seeking injunctive or equitable relief. Injunctive relief would be stopping someone from doing something. Not familiar with
equity anymore.
Right. Government officials performing discretionary functions are shielded from damages liability, quote, insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That's some case law, so made up.
Yeah.
The qualified immunity defense, quote, gives public officials the benefit of legal doubts. All but plainly incompetent officials are protected. That's from another case law, Malley versus Briggs.
In practice, though, like, plainly incompetent individuals are also protected. Like,
the use of qualified immunity as a defense is consistent with federal courts' usual reluctance to decide constitutional questions unnecessarily. And that's an interesting caveat.
yeah,
That's another 2012 case law.
Oh, really?
Yeah.
Wow.
The purpose of qualified immunity is to shield government officials from distraction and to eliminate the inhibition of acting with discretion. That's a 1984 case that was quoted from. Government officials are not expected to determine the manner in which the law's gray areas will be clarified and defined. First Circuit case from 1987.
Right.
Qualified immunity operates to ensure that before they are subject to suit, officers are on notice that their conduct is lawful. 2002 case. Anyways, sorry.
But it's deeply entrenched. This is actually, I believe, if I am not mistaken, Amash's qualified immunity bill would have amended Section 1983. I could be totally wrong about this. This is how I remember it, though. I believe it was going to amend 1983 to say that no part of this statute shall be found to imply that any state actor is immune from suit under this statute. Like, basically just saying, like, there's no immunity for 1983. None. Which is probably the better way to do it, as opposed to making the access to the courts case that I like to make because I'm an idiot who likes to be a contrarian. Because I do think I do in my soul think it's an access to the courts issue. I think it's an issue for redress grievances. I really do. It blocks that while still maintaining its veneer of being inside the system. But yeah, that's kind of an interesting thing that I think it kind of ties into the torts thing, because there are a lot of those causes of action are torts causes of action. Things like false imprisonment, things like assault and battery, things like those are the causes that you would bring to argue that your rights were infringed upon. And they're protected from that.
Let me play devil's advocate for a second. I do think that in a black pill sense, with what the state does today, you need qualified immunity. You need it because without it, the state would be litigated to death. So of course they're gonna grab onto qualified immunity, right. And so yeah, you really do need it.
I had a dream one time that qualified immunity got lifted. I was a practicing attorney, and I would 3D print badges with the name of the cops whose houses I'd taken. Legit, this was a dream I had. Like,
That's a strange dream.
Like, I would 3D print badges with the cop's name and put them on my mantle, like trophies. Like, I took this guy's house, I took this guy's house, I took this guy's house. Like,
Hilarious.
it was wild. I woke up and I was like, okay. I guess that's what's in my soul. But yeah, it's one of those things that you're right. The state would be litigated to death. The state would be, there would be suits all the time.
And for good reason, damn it.
There should be. I mean, this is a situation like there are civil liberties are damn near dead in this country anyway. Like that's one thing that con law, like taking a con law class will black pill you on, especially once you get through Lochner, is like, oh no, civil liberties are dead. This doesn't exist.
Yeah.
This is a lie. They will uphold those liberties, those rights and liberties that you supposedly have when they feel like it.
Yeah.
Otherwise it doesn't exist. Otherwise you're Lochnerizing. And part of that, again, this is one of those things that gets very interesting. And I hate to veer away from torts. I know this is your favorite area of law.
Oh, no,
yeah. This is another sort of instance of that. Like so your right to privacy doesn't exist constitutionally. This is something that you learn. Actually, this is something that I learned earlier. I learned this in undergrad. I took a class as part of my journalism minor that had to do with constitutional law, and it was mostly a First Amendment class, but she had to give us a lot of background. Your right to privacy does not exist constitutionally. It's built around what is called the penumbra of the Constitution. This is a phrase, a penumbra, of course, being a thing that it's a shadow. And you basically go through, what they did is they went through the amendments and they found privacy in the Bill of Rights. Things like the Fourth Amendment, Eighth Amendment, Fifth Amendment, right? They just went through and they were just like, here's my constitutional law professor described it as going through the amendments like a cheerleader and just like, oh, give me a P, give me an R, give me an, right? So in any case, and yet we still make decisions based upon that. Now that is Lochnerizing to the nth degree, just making shit up that's not there. But it's fine because the court says it's fine. And this is the thing that kind of convinced me as soon as I saw that mixed with Lochner. Those two facts in conjunction, yeah, civil liberties are dead. They're totally made up and they'll go away whenever they feel like it.
Okay, you're really going to like this. It's funny how, and I think this is what I want to bring this to an end on. But it's funny how the same people who will criticize the Lochner Era court probably will not mention the Buck v. Bell court.
Buck v. Bell! Dude! Buck v. Bell! Okay. With this vaccine thing, I think we're going to be hearing about Buck v. Bell. I legit think we're going to be hearing about Buck v. Bell. This is one of my favorite cases.
Damn. So, okay, well, for those of you who are familiar or aren't familiar, James Corbett did a great documentary, and I can't remember exactly which one it is, but he talked about Buck v. Bell. In this case, it's a 1927 case of the United States Supreme Court. The opinion was authored by Justice Oliver Wendell Holmes Jr., who is widely considered
to ever sit on the fucking court. I cannot stand that man. My constitutional law professor was throwing like just praising Oliver Wendell Holmes Jr. for being the first justice to have a standing desk and writing so fast. And I'm like, yeah, he wrote so fast because he was too interested in fucking one-liners. He didn't even think about the law. He didn't think about what the actual implications of what he was writing were. Oh, I can't stand him.
Widely considered to be one of the greatest justices of the Supreme Court.
Yep.
So in which the court ruled that a state statute permitting compulsory sterilization of the unfit, including the intellectually disabled, quote, for the protection and health of the state, did not violate the due process clause of the 14th Amendment.
Oh, I'm sorry. Go ahead. Go ahead.
Oh, I'm Wikipediaing this, so I just for
I was going to give a little bit of factual background. This is a case where this was a forced sterilization case.
Yep.
And there was a woman who was being sterilized forcibly by the state for being an imbecile, for being feeble-minded.
I think her name was Carrie Buck, wasn't it?
I believe so. At the time, being feeble-minded meant you got pregnant out of wedlock, or this is one of the things they tested, I believe, her daughter for feeble-mindedness. And the way that they did that was they held up something shiny and tried to see if the baby looked at it. And if the baby didn't look at the shiny thing, they were feeble-minded. That is the science that we're going off of here. And Oliver Wendell Holmes Jr. writes at one point in the opinion, it's one of the worst fucking things he's ever written, aside from maybe Fire in a Crowded Theater.
That was dumb too. God damn it. Sorry. That was about the draft.
I didn't even think about the law. Yeah. He said 3 generations of imbeciles is enough. I believe that's a direct quote from Buck.
Yep. Here's a quote from him. We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, to prevent our being swamped with incompetence. It is better for all the world if instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. You're right.
Yeah.
The Supreme Court has never expressly overturned Buck v. Bell.
It's considered loosely, to some people, it's considered to be anti-canon. This concept of Supreme Court cases that are never to be relied upon. Supreme Court cases like, what was it, Plessy?
Yeah.
Is anti-canon. The idea that the decision that upheld separate but equal is anti-canon. You will never rely upon that. Even if it's for an unrelated piece of dicta in the case, you will still never bring it up because it is such an embarrassment to the court. Buck v. Bell is low enough profile. It has never been, I don't believe it's ever been exclusively called anti-canon. There are some professors who might call it anti-canon. There are some analysts who might call it anti-canon. I do not believe it's considered anti-canon. And this is going to come up. If there are compulsory vaccination rules that come out of the coronavirus thing, Buck v. Bell will be the case they have to base it on.
Yeah. Interesting. I'm so glad I had you on, Dean. I mean, this has been an incredible conversation, I think. not to break my arm patting myself on. Well, you too, man. I mean, this was great.
Nah, go ahead. Pat yourself in the back.
Well, yeah, I mean, I just remember my law professor, my constitutional law professor, he would say, of course, everyone would say how the Lochner court sucks, yada, yada, yada. He at least would bring up how Buck v. Bell was an abomination, but he wouldn't cast that on Oliver Wendell Holmes Jr. or, moreover, his cohort of progressive justices either.
I can't remember. Was Stevens on that court?
Let's see. So. Oliver Wendell Holmes Jr. Nope. Louis Brandeis was. Butler, Sutherland, McReynolds, Sanford, and Stone.
Okay, so Stevens came later.
Taft was the Chief Justice. President Taft.
Yeah. Yeah. It's really funny, actually, to roll back and look at the tenure of Chief Justices and justices on the court generally. It's only recently that they've been around as long as they have. If you go back even a little bit, there are justices that leave after 6 years, 8 years. There are justices that resign in shame. There are justices that are just like, I don't even want this job anymore, and just walk off. Like, justices being on the court as long as they are today is kind of an invention of the last just under 100 years or so.
That's crazy. I think that Tom Woods had somebody on the show who was talking about how in the early republic it was considered to be kind of a burden, and it wasn't an honor to be appointed to the Supreme Court because you didn't do anything. You were,
I believe, governor, I can't remember who it was at the time. I think there was a governor of New York. It might have actually been Taft, who was offered a place on the Supreme Court and said, "Fuck no! Why would I take that that downgrade, that what's the opposite of promotion? I forget the word. That demotion. Yes, obviously. It's almost the exact same word anymore. No. Why would I take that demotion? I don't want that."
Yeah. Well, I think that's a good place to end, man. I'm so glad that I was able to snag you, and we're going to have to do this more often because...
Absolutely, man.
Yeah. Yeah, well...
I like talking about this stuff, particularly because there are a lot of misconceptions, not only about the legal profession, which, again, I'm not a part of, so I don't pretend to be an authority on it.
Not yet, you're not.
Yeah. But I don't, but I do know the misconceptions that I had about it before even going to law school. And I know that those misconceptions are incredibly common. And so I like being able to talk about some of those. I also like being able to talk about the way that the law functions, because it's not the way that people think it is. It's very, very subjective, even when it claims not to be. And I like being able to talk about that, with someone who also knows about it. After the election, I did an episode with my girlfriend, who's also a law student, about the election and sort of the cases that were coming out and things like that. And it was very interesting. And to do that, I feel like I didn't do as good a job there of trying to make it digestible, because we were just sort of going off the cuff and stuff. But I'm very happy to have been here and talk to you about these topics. I find that all so fascinating.
Hell yeah, brother. And why don't you want to take a sec to plug your show?
Sure. My show, Dino Files, exists wherever podcasts are distributed and on alternative internet radio, aarad.io. I think my most recent episode was that post-election episode near the end of November, middle of November, something like that, because I stopped because finals were coming up.
Yeah.
And because we're in Zoom school, I hadn't learned anything all semester, so I had to teach myself all of my classes. I had to teach myself all of my classes in the weeks leading up to finals. Basically. So that was an issue. Anyway, I'll be back to making shows soon.
Honestly, Dean, teaching yourself everything right before finals, that kind of sounds like what I did without Zoom University.
Yeah. Well, it is exactly bar prep.
Right.
People act like you're actually going to remember this stuff from your 1L year when it's time to go take the bar. No. You're reteaching yourself all of law school in the months leading up to the bar.
Oh, for sure. Yeah. I remember I spent, I don't know, a 10-hour day in the library every day, the whole summer. Yeah. I passed really well. To break my arm patting myself on the back again, but
well, it's not easy to do. It's one of those things, okay, I have several problems with the bar. One of which is that they say it's a competency test, but then they curve it. Anyway, they make it unnecessarily difficult to take that test.
Yeah.
And so doing well on it is worth congratulation. It is a test that they put a lot of roadblocks in your way to getting a good grade on.
Well, I know a lot of progressives have started to argue, as they are wont to do, about how it's a tool of white supremacy, which
lovely.
There's I think not the white supremacy part, but there is some truth to it. It's protectionism.
It is very much protectionism. It keeps people locked out of the legal profession who could otherwise be great lawyers. And it also, it kind of goes against what we know of, because, okay, law school is a professional school, but being an attorney is a trade. You're not a scientist. It's a trade. And we know this because it only takes 3 years to go through the actual schooling for it and stuff. It's not being a doctor. Okay. Yeah. It's different. It's not that it's less complicated. It's just different. And there are lay people who could be very good lawyers if they had the opportunity to maybe get their JD and not necessarily go right into practice, but I mean, look, Lysander Spooner was a guy who sued the state to allow him to be a lawyer after his apprenticeship. He apprenticed for a few years. The state said, well, if you didn't go to law school, you have to apprentice for longer. And he said, no, I don't. Sued them and won. So you don't have to, I mean, apprenticeships work. We know this.
Right.
That's my hope.
I was just going to mention Lysander Spooner, and I'm glad that you did, because I was going to say his first act as a lawyer was to sue for admission to the bar.
That's exactly right.
I mean, moreover, I would say, moreover, though, that the most valuable experience that I got in law school was clerking. You know, it wasn't the classes, it was clerking and appearing in court.
Yeah. That reminds me, I need to start getting ready to send out applications for internships.
All right. Well, we'll have to do this again, but any last plugs before we say goodbye?
Not really. The rogue file exists. That's a thing that I write on sometimes. I want to get back to writing on there a little bit, but there's frankly not. Writing takes time, and especially when you're writing kind of pseudo research stuff like I do on the rogue file, it takes even more time. And time is not something you have an abundance of in law school. So it's but I'd like to start writing there. But if you'd like to read old articles, the rogue file exists, roguefile.com.
Okay, I'll put that in the show notes page. But anyways, Dean, so great to talk to you. I'm glad we could reconnect, and we'll do it again for sure.
We need to. I have so much fun every time I talk to you.
Right on, brother. Okay, peace.
Peace.